It is the revelation that turns the entire life sentence judgment on its head and exposes the hidden legal war that was fought and lost behind the closed doors of the Federal High Court. If you thought Mazi Nnamdi Kanu's refusal to defend himself was an act of arrogance or madness, you need to listen to this very carefully, because the man who led that strategy, Barrister Aloy Ejimakor, has just released a bombshell explanatory document that tears apart the legal foundation of the conviction. The headline you saw is not just an opinion, it is a confession of strategy, a blueprint of the defense that never was, and a damning indictment of the judicial process that sent a man to Sokoto prison for the rest of his life. We are broadcasting this deep dive special on Saturday, November 29th, 2025. To dissect the explosive article released late yesterday by Aloy Ejimakor titled Reasons Why We Blocked Nnamdi Kanu's Trial. This document is not just a press release, it is the secret weapon that the defense team believes will overturn the conviction at the Court of Appeal. We are going to walk you through every single legal trap they set, the zombie law they refused to dignify, and the double criminality test that the federal government is allegedly terrified of. To understand why Nnamdi Kanu stood in the dock and shouted, "Show me the law," we have to go back to the very beginning of the charge sheet. Ejimakor reveals that all the terrorism-related charges against Kanu were predicated on broadcasts he made between 2018 and 2021. Now, pay attention to the location. These broadcasts were not made from a studio in Lagos or Abuja. They were made from outside Nigeria, specifically from the United Kingdom and Kenya. The government charged him under the Terrorism Prevention Amendment Act of 2013. This 2013 law was the government's favorite weapon because it granted the Federal High Court extraterritorial jurisdiction without any complex conditions. In simple English, under the 2013 law, it didn't matter if you made a speech in London or on the moon. If the Nigerian government felt it had an impact in Nigeria, they could try you for terrorism. It was a blank check for the prosecution. But here is where the legal earthquake happens, and this is the core of Ejimakor's argument. In 2022, while Kanu was sitting in DSS detention, the Nigerian National Assembly did something that changed the game. They repealed the 2013 Act and replaced it with the Terrorism Prevention and Prohibition Act of 2022. This new law introduced a massive hurdle for the government called the double criminality test. Section 76 of the new 2022 Act states clearly that for a Nigerian court to try someone for an act committed abroad, that act must also be a crime in the foreign country where it happened. This is the magic bullet. Ejimakor is arguing that for Kanu to be guilty of terrorism in Nigeria for a broadcast made in London, the British government must also classify that broadcast as terrorism under British law. This is why the defense team blocked the trial. They knew that political speech, agitation for self-determination, and even fiery rhetoric are protected under free speech laws in the United Kingdom. They knew that the British government does not consider Radio Biafra broadcasts to be terrorism. Therefore, if the court had applied the 2022 law as it should have, the case would have collapsed immediately because the double criminality condition could not be met. The prosecution knew this too. That is why, according to Ejimakor, they stubbornly insisted on trying him under the old, dead, repealed 2013 law. They were trying a man in 2025 using a rulebook that was thrown into the trash can in 2022 because the new rulebook would have set him free. This is the sophistry Ejimakor talks about, a legal trick to avoid the substantive safeguards of the new law. The legal team's strategy was to force the court to answer one simple question. Which law are we using? It seems like a simple question, but it is the difference between freedom and life imprisonment. When the case was reassigned to Justice James Omotosho in February 2025, after Justice Binta Nyako recused herself, it was supposed to be a trial de novo, which means a fresh start. Under long-standing Nigerian jurisprudence, when you start a trial afresh, you must use the law that is currently in force. You cannot go back in time and pick a law that favors you. The defense argued that you cannot try a defendant under a repealed law when a new, more favorable law exists. This principle is not just Nigerian, it is international. it is the principle of retroactivity and fairness. But the court, in its rush to judgment, allegedly bypassed this gatekeeper. Ejimakor paints a picture of a judicial ambush. He explains that while the 2022 Act does have savings clauses that preserve ongoing cases, those clauses do not save jurisdictional defects. Double criminality is not a minor detail, it is a condition precedent. It acts as a gatekeeper. If you don't pass the double criminality test, the court has no power to even open the file. By refusing to apply this test, the court was essentially acting without jurisdiction. This explains Kanu's frustration and his outburst in court. When he shouted, "Show me the law," he wasn't being unruly, he was asking a fundamental constitutional question. Show me the valid existing law that allows you to try me for something that is illegal in the UK. There is another layer to this blocking strategy that involves the charge sheet itself. Ejimakor points out a fatal flaw that many overlooked. The charges against Kanu failed to specify the foreign country from which the broadcasts were made. They just said, outside Nigeria. Why is this vagueness important? Because it robbed Kanu of his right to a fair defense. If the charge doesn't say London, how can Kanu's lawyers bring evidence from British law to prove his innocence? If the charge doesn't say Kenya, how can they cite Kenyan statutes? By keeping the location vague, the prosecution prevented the defense from activating the double criminality argument. It was a tactic of ambiguity. The Administration of Criminal Justice Act, ACJA, bars jurisdiction if a charge omits legally required information that misleads the defendant. Ejimakor argues that the identity of the foreign country is a jurisdictional fact, not just a detail. Without knowing the country, the court cannot even begin to ask if the act was a crime there. This reveals that the decision to block the trial, to refuse to enter a defense, was not an act of surrender, but a strategic protest against a trial they believed was fundamentally flawed. They were effectively saying, we will not validate this illegality by participating in it. They wanted the record to show that they challenged the jurisdiction at every turn. They believed that this specific error, trying a man on a repealed law and ignoring the double criminality test, is the banana peel on which the life sentence will slip and fall at the Court of Appeal. However, we must also look at the counter-argument that is simmering in the legal community. Some critics, including Kanu's former lawyer Ifeanyi Ejiofor, have argued that this strategy was high risk and ultimately fatal. They argued that by blocking the trial, the defense team handed the prosecution an open goal. Because Kanu didn't defend himself, the evidence brought by the government went uncontroverted. The judge had no choice but to accept the government's narrative because there was no counter-narrative on the official record. Ejimakor's article is a direct response to this criticism. He is arguing that participating in a flawed trial would have been worse because it would have waived their right to challenge the jurisdiction on appeal. He is betting everything on the superior court correcting the errors of the lower court. This brings us to a very serious conversation about the nature of our judicial system. If the law was repealed in 2022 to provide more protection to citizens, why was it ignored in the most high-profile case in the country? Does the national security card trump the actual written text of the law? The implications of this are terrifying for every Nigerian. It suggests that the state can pick and choose which version of the law to apply to you depending on how much they want to convict you. If they can use a dead law to jail Nnamdi Kanu for life, what stops them from using dead laws to jail journalists, activists, or political opponents? The revelation that the broadcasts were political speech made in the UK raises the issue of sovereignty. Is the Nigerian court overreaching by criminalizing speech made on British soil? If the UK government granted Kanu a license to operate Radio Biafra, which is a registered company in London, then his activities were legal in the eyes of the host country. For Nigeria to reach across the ocean and criminalize a legal business activity in London is a massive expansion of judicial power. This is the extraterritorial overreach that Ejimakor is challenging. So, Where does this leave us? Nnamdi Kanu is in Sokoto prison. The life sentence is on record. But this article by Aloy Ejimakor has laid the roadmap for the appeal. It tells us exactly what the legal battle will look like in the coming months. They are going to the Court of Appeal not to argue about whether Kanu made the broadcasts. Everyone knows he did. But to argue that the law used to convict him was a ghost. They are going to argue that you cannot build a life sentence on a foundation that was repealed by the National Assembly. This is a gamble of historic proportions. If the appeal court agrees with Ejimakor, Nnamdi Kanu walks free and the entire trial is declared a nullity. It would be a humiliating defeat for the federal government and the vindication of the blocking strategy. But if the appeal court rules that the savings clauses in the new law allow the old charges to stand, then the gamble has failed and the life sentence becomes cemented in stone. The question you have to ask yourself is this: was this strategy genius or suicide? Did the legal team save Kanu's chance for an appeal by refusing to legitimize the trial, or did they simply annoy the judge into handing down the maximum sentence? The line between a brilliant legal maneuver and a catastrophic error is often drawn by the final verdict. Right now, with Kanu in Sokoto, it looks like a loss. But Ejimakor is telling us, wait, the game is not over. The law is on our side, even if the judge wasn't. As we digest this detailed legal exposition, the tension in the Southeast remains palpable. The people are waiting to see if these technical arguments can actually open the prison gates. They are tired of legal grammar. They want to see their leader. But for now, the only thing standing between Nnamdi Kanu and a lifetime in prison is this argument about double criminality and repealed laws. It is a thin thread, but it is the only thread they have left. We will continue to follow this appeal as it moves to the higher courts. We will bring you the counter-arguments from the prosecution when they respond. But for today, we have seen the defense's hand. They are banking on the fact that the law cannot contradict itself. What do you think? Is Aloy Ejimakor's argument about the repealed law strong enough to overturn a life sentence? Or is it just legal gymnastics? Let me know your thoughts in the comments.